And it should be Erica Ward and Aaron Ward.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixing Housing, 401k plan.
Donna Tope on behalf of Aaron Ward and Erica Ward. Tenants on the lease.
Okay, where are we on this case, folks?
Your Honor, so the last time we were here, if you need me to get into that, you denied defendant's motion to stay the eviction
Correct.
and transfer the eviction case to the circuit court. You ordered tenants to produce a full accounting with receipts of money placed into Ms. Tope's escrow account
Yes.
and of transactions made for repairs and purchase of supplies. You also ordered prorated November rent and rent going forward into district court escrow.
Correct.
We had a hearing on Wednesday on the circuit court action.
Yes.
And as you recall, plaintiff or tenants brought the circuit court action. We filed right away a motion to compel payment of rent. And the circuit court denied our motion for lack of jurisdiction, basically leaving it for you. Your Honor.
They did?
Your Honor, we don't.
Who was that?
Judge outside.
Okay, thank you.
She's retiring.
Pardon?
She's retiring.
I understand that,
Yeah.
but,
She didn't want it.
no,
Your Honor.
no, never say Judge Outside never wanted to deal with it, because that's not it at all. If she felt this court had jurisdiction, that's what she felt.
Exactly. Your Honor, I have the transcript from Wednesday's hearing, if you'd like that. Or do-
I may need it, but hold on. So that was denied, and so the rent issue is now planted firmly in my lap.
In this court, correct.
Okay.
We can go into the accounting if,
Do I have an accounting?
Yes. I filed it on Monday. With receipts. November 10th. With receipts, and the last page is the final accounting as of that date.
This is the one with the invoices attached.
Yes. You asked for,
Oh, no, I know what I asked for, but, go ahead. What were you gonna say with regard to the accounting? I see this document. Go ahead.
Your Honor, one procedural point. We only received a copy of the accounting because it was e-filed in the circuit court. So I would say service would be improper for the accounting for this court. But I would say to be frank, the accounting is a mess and it's wholly inadequate. I have many questions for Ms. Tope, which I think really highlights the problem here that opposing counsel has inserted herself into this litigation. As the court correctly stated last Friday, there's no legal authority allowing opposing counsel to handle and disperse these funds to contractors and for supplies, especially when these funds were owed to my client under the lease.
Hang on a second, counsel.
Yes.
Ms. Tope,
yes,
I'm going to ask you a difficult question. I may stop you from answering at some point because I'm not trying to bait you into anything. But these individuals are your clients who, and you're their attorney. They at some point gave you funds, right? Were the funds placed into your IOTA?
No.
Oh,
Can
I got a whole other problem. Because,
Your Honor,
yes,
let me start at the beginning.
no, you're not going to start at the beginning.
Your Honor,
Because, no, you're not going to start at the beginning.
this,
Miss Tope, you know what? You say, oh my goodness, one more time, and I'm going to find you in contempt. I'm stopping you from committing a grievable offense. That's why I told you at the very beginning that I may stop you after my answer, after you gave the answer. Because you have a tendency, when I ask you a yes or no question, to continue to go on and on. And you are going to get yourself in serious trouble. Very serious trouble. I ask specific questions for very specific reasons, because at some point, here's going to be the problem, Ms. Tope, and I'm just going to lay it out this way, and I'm going to try to lay it out without placing any sort of finding or what I'm thinking. If you, as an attorney, are given funds by your client, you must hold those funds in trust. That is typically done through an IOTA account, particularly if you are then dispersing your client's money on their behalf to third parties, to others, or court, whatever it is. You then have to have an accounting of that. Moreover, when I start looking at the dates, at some point, these would be required to be reported. Yes, I'll just leave it there. You're going, this intake and disbursement, on the face of it, had to be done in a particular way. Now, there may be something about the transaction that I don't know, but on the face of it, that's what it looks like.
I totally understand what you're saying. Our case filed before the circuit court was filed on July 9th. They had jurisdiction of that breach of lease case. Part of the breach of lease case was that the landlord did not make necessary repairs for the health and safety of all those who were benefited by the lease. We notified them in that case that we would withhold, that they had been requested to make the repairs. They had declined since 2023. We had to make them for the coming winter for the horses and the people that were there. We notified them in August that they paid the rent in July. We notified them in August that we were going to withhold rent and make the necessary repairs themselves, mitigating, trying to correct the problem. They filed their summary judgment here in this court, which I agree, under a summary judgment, a trust fund would be set up. When they filed on October 20th, this was after months of making repairs.
Stop.
That's when this court got
Getting things confused.
Pardon?
Getting things confused with what I'm saying and with what you're trying to argue.
Mhm.
I get with reference to any escrow order that the court initiates.
We asked for them.
It's what you did before that, Ms. Tobe, that I see as being problematic. You're acting as an attorney, and I'm just going to say this again, and you take into your possession client funds and then disperse them. So I'm going to put it in the most general sense I can. That has to be done in a particular way with certain accounting that comes with that and certain accounting that must then be recorded. What is, well, I'm not going to say it's clear to me because I will say I have very serious concerns as to whether or not that happens or happened. Which, Ms. Toe, may, I'm not saying it will, may subject you to certain liabilities, potentially with the state bar.
That would be because of the circuit court case.
So, I'll be honest with you, I'm not the one that you're going to have to explain it to. I mean, but I'm doing my best to say that on the face of what I'm seeing, you may be in jeopardy of some adverse consequences because of what's occurred. That's what I'm saying. What I'm also saying, it's troublesome from the court's perspective because when you refer to you and your clients and certain things that have been done, and this is what happened, and I hate bringing up other cases with reference to present cases, but you keep referring to we, in terms of your clients and you acting. Sometimes that is absolutely appropriate, and it just is. It's just language. Part of the court's hesitation when you are saying it that way is that, and again, I'm saying this and I'm not making a finding, but if you were operating, I'm going to put it in form of hypothetical, and I hope you can follow it. If your clients were following your advice to place the monies with you and then pay the money out, where that may be in violation of the plain language of the lease, right? They may have a claim, whether they choose to pursue it or not, as to you.
I understand what you're saying.
And so that's a problem for the case proceeding because you can't be, you're representing them, but as to the position that they in the business should take, on the face of it, when I look at it, you have a conflict in terms of that.
Okay.
And outside of the fact of the first thing that I said, where you might be in violation and I'm not saying you are, and I hate even making the accusation of ethical rules that would apply to attorneys taking clients' money into trust.
I understand.
And again, I will give this blanket statement. I am not saying that making any accusation. I'm not making any finding. I'm not saying any of that. I'm not saying even to a great extent my analysis, if I were to come down to the end of it, is correct. All I'm saying is that's what I see on the surface.
And your statement that you said was that if I, as their attorney, gave them advice to do what your hypothetical is suggesting, in this situation, the client asked me to handle, because of the lease, the violations of the lease and the threats that the Fixing Housing made before they filed this action, when we had to file the action in circuit court. Because of the threats, she wanted to have, my client wanted to have everything I's dotted, T's crossed, so that he would not be able to claim that she had not done what tenants are allowed to do, which is, if the landlord does not make necessary repairs, which are the terms of the lease, the tenant is allowed to withhold rent, take on the repairs themselves to make the place safe for their boarders and their horses.
What's the operative word you're using in that whole statement?
Pardon me?
What's the operative word you're using in that whole statement?
The operative word is,
Assuming you're correct on the law, which is a little bit iffy, but that the tenant may.
she asked me to make sure that he wouldn't be able to proceed on his threats. And I agreed to just oversee the,
No, you did more than just oversee.
well,
That's the problem.
and Your Honor, what, in this situation, we're here before you. We requested at our last hearing for you to set up an escrow account, a trust fund with the court to accept rent going forward.
So I understand that. I know what I did.
Mhm. That's what we're here to move forward with. Are you not going to allow me to represent my clients going forward?
Ma'am, I've not had a motion to force an attorney's withdrawal in this case. If I make that decision, then I certainly can make that decision on my own motion, but I don't have enough before me that I would feel comfortable making that decision. It is a monumental decision if a court directs that to happen. I will say, Ms. Toe, I'm concerned as to whether or not that's where we end up.
That will, excuse me, I didn't hear.
I'm concerned that that's where we may end up.
I share that concern. I would like to know how you would like us.
Well, I'm okay. So here's what I'm going to do, folks. And I really don't like delaying things. I like to try to keep things moving along. But Ms. Toe, because of the things that I've said, and I think you need to take what I'm indicating to you very seriously. Because there's no reason for me to I really don't have a dog in that fight. There's no reason for me to say it other than the fact that you're facing jeopardy on a number of different levels. And so I'm going to do this, and I realize that it delays plaintiff, but I think the court is compelled to do this. I'm going to adjourn 1 week to the 21st at 3 p.m. And the basis upon which I'm adjourning is I think, Ms. Tope, you need to get the advice of counsel
Got it.
as to how you should move forward and if you should move forward.
Got that.
I also think, although I'm not ordering the defendants to do it, because I can't do that. I might suggest to you that if you've listened to what I've said today, if you believe in your interest to seek the advice of other counsel as to how you should proceed, I'm also giving that week for you that opportunity, should you so choose to do so, for you to do that. I'm not advocating for or against that. I'm just saying I'm giving you the opportunity so that you can make that decision based upon what the court has said. Okay? Anything else?
As I said at our hearing on last Friday, I'm scheduled to leave town for Thanksgiving vacation on the 20th.
Ms. Tope, I know, but I
Okay,
don't know what
can I appear by Zoom?
you can submit the paperwork. I don't know if I'm going to allow it or not. I'm not answering that right now. I mean, because I don't know on what, quite frankly, from week to week with this case, I'm not sure on which capacity you're going to be appearing. So you can submit the paperwork and then do that. I'll leave it there. I mean, I have a lot of concerns here, folks. I just do. Anything else from the plaintiff?
Your Honor, just so it's on the record, the court doesn't need to untangle the mess with Ms. Tope's accounting. But as the court correctly stated last Friday, the lease language is non-conditional. Tenants are required to pay base rent of $5,500 per month without any deduction or set off whatsoever. There's no factual dispute that tenants have withheld rent. They admit it. And longstanding Michigan case law in the commercial context, tenants' duty to pay rent is independent of landlord's alleged covenants to repair.
Okay. So what do you want me to do with that?
Say, to avoid untangling that mess.
That's
clear.
No, but here's the thing. And there are certain, and I get what you're indicating, but I'm in a different boat. Understanding what you're saying is if a tenant recognizing their covenant to pay simply withheld the rent to try to get the landlord to do something. That's a different posture. Maybe they can do that. Maybe there might be a breach of contract in that regard. Whatever. In theory, that wouldn't be allowed either, right? But we have another problem here because not only was that part done, but as I'm to understand, then those funds were then dispersed elsewhere. That creates a whole different ballgame. It creates a whole different ballgame, particularly where you're claiming a breach as to who did it. right?
Yes.
And
Yes, Your Honor.
that, so while I recognize and understand what you're saying,
Your Honor, I would.
it's all a mess, and they're sort of a mess on both sides. Less of a mess over here, more of a mess over here. I gotta try to clear that mess before I can even begin to deal with that. I've always wanted to use mess as a legal term. Go ahead.
It may be a term of art. I would just say it's the mess that's being caused by tenants, and they're responsible for the actions of their agent, is causing my client prejudice where he's not getting paid any rent, and tenants are operating their business on my client's property rent-free. So my client is the one who's being prejudiced by the mess.
And counsel, I'm well aware of that, which is why I'm trying to at least make some decisions, understanding the other action that was going on, but make the decisions within the confines of this month, which is why I'm not moving beyond. I realize that there is prejudice to your client, at least in terms of the funds being there. As I'm sure you understand, the other issues over here, I've got to deal with, because I think unless they're cleared up, it's going to be even more prejudice to your client, because you're going to be Don Quixote in terms of who you're trying to argue against.
Understood.
And that has to be solved. That's also why, despite Miss Tope's travel plans, I'm not going to my next date of December 5th.
Okay.
Because I don't know that come the 21st will resolve anything. But I got to give that opportunity over here. I have to allow that to occur, I think, in fairness, and just to make sure that the proceedings are what they are.
Understood, Your Honor.
Can we address the order that you gave to set up an escrow account and how much should be put in it? Because the plaintiff in this case was paid $3,600 and some dollars for the rent on November 1st. Are they to put that into the court-ordered escrow account?
What I ordered at the last hearing on the 7th,
Mhm.
the monthly rent is $5,500,
Yes.
correct?
Correct.
What I ordered was that $4,125 was to be placed in escrow by the tenant.
By today,
Yes.
right. Is that?
And then $5,500 going forward. Pardon?
Is that the November 1st rent payment or?
I prorated November.
Okay,
That's how I get $4,125.
okay. So the check that they got for 3,000 some hundred needs to be put into escrow.
So where's the 3,000 come from?
November rent, and the only amount that was withheld for necessary repairs was taken out of that. That is, my accounting is, I tell you, it's not a mess. The accounting is very clear, and the exhibits for every invoice that was paid is very clear.
Okay. So the last time we were here, and I can't recall independently what the amount of the check was. Did you receive that check?
Your Honor, yes, we received it yesterday. And we sent a reservation of rights letter to.
Okay. So that was for how much?
$35.08 and 96 cents.
Oh, for Pete's sakes.
It was sent on November 1st before you made your order to prorate. So we are prepared to make the difference.
And the deduction from that are
Yes.
what?
It was, the temporary repair of the leaking spigot out in the pastures before frozen ground. And we asked them to please repair it, and we got no response. And
Hold it.
you know, the
Hold
ground
it.
froze
Hold it.
last week.
Well, it didn't really freeze last week.
Well, it would not, it would have frozen in the
Michigan,
spigot out in the.
that was not a freeze.
It was 27 degrees for 2 days.
I know what the temperature was. I'm just telling you. It was not a freeze of the ground.
There was frozen ice in the
Oh,
bucket.
for Pete's sakes, all right, fine, it's frozen ground. I don't care. That was not a, we had frost.
For a spigot out in a pasture to give water to 1,200-pound horses, 35 of which are on the property, we needed to have a fixed spigot that wouldn't freeze. And that's what was withheld from the $5,500 rent due 11/1.
Let me ask you this. Did you cash the check?
I told my client not to cash the check because I knew about this hearing and we had to send our reservation of rights letter. So we still have it. It would seem like triple, prejudice if he now has to give it back. And I don't understand really why opposing counsel decided to release this amount. I don't know, Your Honor.
Either.
It's in the accounting that
And
was
it-
filed.
It came right before our motion to compel payment of rent hearing.
Here's what
I will leave that there.
I'm gonna, you know what? Ms. Tobe, I don't believe that on the face of it, your clients had the right to withhold any portion of that base rent. On the face of it. Now, it may turn out once everything's litigated, something else comes out in the wash, but on the face of it, they're not entitled to do it.
They asked him to repair the middle of October.
Okay.
Got no
You keep
response.
saying that to me. I don't know why people don't think I hear. I hear everything. You saying it to me over and over again doesn't make it more true. I hear you. I can hear all kinds of people. I do it every day. That doesn't mean that I agree with you. So, since, as I see from this, just the lease language itself, that they would not have been entitled to do that. Plaintiff may do what they wish with what they got. I am not changing my order of November 7th so that the 4125 must be placed into escrow with the court and then 55 each month. If it turns out, so that your clients understand in the end, that what you were doing was all, then seeing the accounting, and I'll do the math, and we'll figure out what needs to be paid or what gets credit. We'll figure that out in the end. But at this point, 4125 is expected to be an escrow.
Paid by my clients. What about the check that they received? Is that to be returned? Not,
No, I'm not going to order them to return it.
They can cash that check.
Yes, because here's the problem, Ms. Tope. You're making your own like accounting and math up on the ledger. Because you're saying, well, we sent this for November, and so therefore they need to send that back to us before we pay the prorated amount of November rent. Well, that would go against every accounting principle in the world because he applies it to the oldest debt, which is the month he didn't get paid, which is not the first month he didn't get paid, which is not November. So if he applied that to that, November hasn't been paid. So whether anybody likes it or not, we're going to use my accounting, my math. That's what we're going to do. So I'll make it real clear for everybody. They keep the check. You've got to pay $41.25 into escrow and then $55 beginning December 1st. Any other questions from anybody?
Nope.
Your Honor.
Fantastic.
Thank
We'll
you.
see you next week, 3 p.m.
Don't know? All right. Well, why not? I can do civil and criminal all at once. It's schizophrenic before. Oh, Garen. Pasco called. I'll talk to you. All right. Clark Road Family Dividend Housing versus, is it Deschanel Baker?
Good morning, Your Honor.
Good morning.
I do have two witnesses. Would you like them to remain there or
Pardon?
where would you like my witnesses to come?
They can wait where they are.
Over there? Perfect.
What are we doing?
Okay. Your Honor, we've already,
I'm sorry, where am I supposed to go?
right here.
Right here.
We're a little crowded.
All right. State your name.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Your name?
Deschanel Baker.
All right. What are we doing?
Yes, Ms. Baker has already provided possession. So today was just an issue of money damages that were requested.
All right. And you're unable to agree on that figure? Is that?
No, sir.
Correct. We do not have an agreement, Your Honor.
Not have a fee.
Correct.
How far apart are the parties?
I haven't spoke with anyone from the property since I've turned my keys in, so I haven't been able to come up with an agreement from anyone.
Your Honor, if I
Go
may,
ahead.
the defendant has indicated that she has had habitability issues. It's my client's position that there was no habitability issues, and she is requesting damages in the amount of hotel bills that we did not receive, as well as, again, indicating a habitability issue. So we are very far off.
Your Honor,
Would you like us to speak in the hall momentarily, Your Honor?
I probably would, but hold on. What were you going to say?
Your Honor, I'm not asking for any money in return. I'm just asking for the charges to be dismissed and for no eviction to be on my record.
Okay. I understand that last part. What is the total amount of plaintiff's claim?
Including court costs, it would be $3,055.63.
And ma'am, but the court's understanding you disagree with that because you weren't in the premises?
I disagree with that upon many factors. In the landlord's response to my counterclaim, it includes a statement that on August 6th, I denied entry to maintenance and they could see the fan because of the entryway. That is not true. I have proof that I actually asked management to meet in the leasing office to discuss my concerns, and the manager refused to meet me there. She chose to come to my apartment instead. This shows that I wasn't denying access to them. I was just asking to talk in a proper and safe environment to resolve the issues that I had, not only with just the leak and the mold and my pet dying in regards to everything going on in my apartment.
majority of your claim, how much of that is rent?
$2,207.
I'm sorry, there was a sneeze.
$2,207 for rent, $90 for the washer and dryer rent. Legal fees was $239.40. Additionally, there were unpaid utilities of $94.23.
Unpaid utilities.
Correct, Your Honor.
Okay.
And we do have the bills from DTE and consumers regarding that. And then, or I'm sorry, I think it's just DTE. And then the damages was the amount of $425. And that does reflect a cleaning fee. There was a secondary repair with the drywall due to tenant caused damage. And just a moment. And then there was a bulk fee where they had to remove bulk furniture from the unit after she moved out. And then there was also a replacement of the disposal system due to tenant caused damage.
Yes, upon me moving out, there was nothing wrong with the apartment. With me leaving, the disposal working.
Hold on, man. Were you in a hotel or not?
I was staying at family, friends, and relatives. I'm currently couch surfing. I don't have anywhere to stay.
Well, okay. I mean, during this period in time, were you in the unit?
During this period of time, I was not in the unit. I was staying at a family friend's house.
Had you notified the landlord of that?
Yes, I did.
In writing?
Yes.
You
I
have a copy of the writing?
I submitted a paper in writing stating that I would not be paying rent and I wasn't staying in the property.
I understand what you're telling me.
Mhm.
Do you have a copy of what you gave to the landlord?
Yes.
All right. Have you shown the landlord that?
Yes, Your Honor. The defendant also refused entry for repairs during that time without her being present. And so our argument is that she failed to mitigate the damages. Additionally, repair was made that same evening to the leak in the ceiling that was caused by the HVAC system above her unit. So it had leaked through. She called in sometime after hours. By 10:30, 11 o'clock that evening, we have maintenance here on site to provide testimony that they provided immediate repairs, including fans. Within a week, they had a professional carpet company out there that provided additional remediation, including repair or cleaning the couch and the rug. And the repair itself was completed by the 19th.
Your Honor.
And this occurred on the 5th.
Your Honor, that's not true. On the date, I was at work that they came to repair the apartment. Maintenance entered my home.
Ma'am, let me ask you this. Did you let them into the unit
Yes.
to make the repairs?
Yes. The date that she mentioned, I was not home. The maintenance guy called.
Are you disputing that they made the repairs?
No, I'm not disputing that they made the repairs. They did enter my home and make the repairs.
Okay.
On the 19th, after the leak happened on the 6th. They did not reach out and let me know when they were supposed to come. I had got no notification when the repair was supposed to be made. I had went up to the office multiple.
But why would that?
I'm sorry.
Why would that matter?
What's your question? Why would what matter?
You called in a leak. They came and fixed it. We're all in agreement on that.
They did not come. I called in the leak. No one communicated with me. I called in the leak the night that it happened. 2 employees came and he pulled out where the leak had came from because they said that they had not fixed or changed the filters out. The filters were supposed to be changed every 6 months. I had been living there for 9 months and nobody came.
That's fine, but that you called in a repair. What you're telling me is that they came out that night, right?
They came out that night and put a blower in my house and just told me to leave it on the ceiling and on my furniture that had been ruined. Yes.
But
the leak was not fixed that exact night.
okay, but they don't necessarily have to fix it. They tended to what your complaint was, right?
Correct.
And then at some point within those next 2 weeks, they fixed it. You would agree, right?
No, it was not within 2 weeks.
I thought the 16, 19.
One minute. Your Honor, the drywall took additional time.
The drywall,
The drywall took additional time.
but the leak was fixed.
The leak was remedied. And then once the leak was confirmed, they did wait, I believe, a couple of weeks to confirm that the leak was finally
Was
fixed.
final.
And they had a
The
third
drywall.
party, correct, and they had a third party drywall company come out to provide repairs. At that time, once the repairs were complete, the tenant did, or the defendant did come back home. There was wet paint from the repair, and she proceeded to poke a hole back through the ceiling. That is where the charge came from. The property did not charge her for the initial drywall. They charged for the secondary repair because she poked a hole in, alleging that it was moisture from the leak that had not been an issue for several weeks.
Did you do that?
additional repair.
Maintenance had previously told me that if a
Okay, hold on. Now, you need to answer my question. Did you put a hole back in the drywall?
no, I did not intentionally put a hole back in the drywall. I allowed the water to flow into a bin instead of on my couch.
After they made the repair?
Yes,
What date was that?
19.
Your Honor, we have a photograph of the hole in the ceiling that indicates it's over the door. There's no couch underneath that photograph.
Your Honor, the hole where the leak had happened, my furniture was there. They had, in their counterclaim, said that I denied them entry and that I damaged their property. I was just trying to get my problems resolved so that I could leave the property voluntarily. I was reaching out to compliance and upper management to
This
discuss.
rent is for what period?
It is for the period of July, August, and I believe part of September.
I moved out September 17th, right after our first hearing,
And the leak occurred when?
August 6th.
So why wasn't July paid?
July wasn't paid because I discovered black mold in the building.
Your Honor,
In the building?
Yes. Throughout the building, there was black mold.
Was there black mold in your unit?
No, sir. There were immense other problems that I was facing while living there that contributed to me not paying rent.
Tell them you weren't paying rent?
in August, my client received notification in August after the repair had been partially made and the drywall was pending, indicating she was not.
How long, when did you move in?
I moved in January 24th of
So
2021,
January,
but they,
hold on. January, February, March, April, May, June, you paid rent.
yes, on time every month
So the black mold came in when?
in July.
All of it?
Yes.
It just appeared.
The black mold, it came from an apartment that was also leaking water on the first floor. There was also an apartment leaking
So
water.
the
on
black, hold on, the black mold just started to exist in July?
The black mold did not just start to exist in July. It's when I became aware of the problems that not only I was
So when
facing,
you
but the other
didn't pay
tenants.
July, did you tell them this is why I'm not paying my July rent?
No, Your Honor.
Then you've got a problem. Even if true, which I have my doubts. So what I'm going to suggest you do, and then is why don't you take a moment to talk
Yes, Your Honor.
and see if you can resolve it. I will let you know, young man, I'm seeing certain problems with what you're telling me regarding any type of solution to this in terms of the monetary amount. But we can all have our positions. I'd suggest that you talk with counsel and see if you can work it out. If you can't, then I'll take you back and we're going to work it out.
Okay.
Thank you, Your Honor.
But I don't know that you really want to talk to me today. But I'm always happy to talk to you. Thank you.
Thank you.
Thank you, Your Honor. Good morning, Your Honor. Attorney Samantha Sprague, Pete 1931, appearing on behalf of the plaintiff.
Hi, Your Honor. We weren't able to come to
I
an
need
agreement
your
with the
name.
Dejanay Baker.
All right. Are we on that?
We weren't able to come up with an agreement. I would like to request that this case proceed to trial. I've been dealing with ongoing issues regarding Huron Vista, including attempts to charge me additional amounts that I don't believe are fair. I also want to note that when I moved in, I was not given a properly signed lease. There were more inconsistencies with rent charges, my move-in date, and prorated
Ma'am,
rent.
did you pay the rent?
Huh?
Then I don't know what you mean by a properly signed lease.
When I moved in, I did not have a signed lease. I did not sign a lease.
Okay, but you stayed there, right?
Correct.
You paid rent.
Under the impression I had a signed lease.
That's the only reason you paid rent?
No, Your Honor.
In the moment you stayed there and paid rent, you created, the tenancy was created. So I'm not sure why you are bringing up the fact you're saying there wasn't a properly signed lease.
Because I would like to move forward and take this to trial. I don't believe I'm getting my points across.
You don't believe what?
I'm getting all of my points across.
Oh, no, I'm understanding them. But they, quite frankly, I'll be honest with you. I mean, I'll hear the case, had evidence to put on, but I'm not clear what you're really arguing.
What I'm arguing is that I did find the paper that I reached out and submitted in writing about the black mold when I found it in July. I did reach out to the apartment complex. I would like a court-appointed attorney. I don't feel
That doesn't happen in the civil case, ma'am.
okay.
If you're going to go to trial, you're going to have to try it yourself. And my question is, are you prepared to do that? Because you're going to be bound by all the same rules, the court rules, evidentiary rules that counsel would be bound by.
Yes, Your Honor, I understand.
You're prepared to do that?
Yes, Your Honor.
I don't understand what your defense is to this.
My defense is that since I've lived in this apartment complex, I have not gotten any communication in regards to my problems that I faced living there. I've reached out and talked to more than 5 property managers that's worked there in the past 9 months. All of my problems were not fixed. They were completing work orders that were not actually completed. They were just marking them as complete.
Ma'am, what did they not do?
Anything.
No, that's not an answer.
They did not fix the leak. They did not. I'm sorry.
What do you mean they didn't fix the leak?
Give me 1 second. Landlords are legally required to keep the.
I don't need to be read anything. You have told me that they did not fix the leak. I just went through the whole thing. You agreed they fixed the leak. So what do you mean they didn't fix the leak? Maybe he's doing it.
What I mean by they didn't fix the leak, they did not communicate with me as a tenant to give me the communication of when they were going to enter my apartment and how everything was going to get handled. No one communicated back to me in any of the responses when I've reached out to them and let them know the problems that I were facing living there.
Did they fix the leak?
Yes.
So what do you think them, if it's true, which I'm having some doubts that they didn't talk to you at all, what are you claiming that's worth?
I'm claiming that that's worth the $1,790 that they initially brought me to court for.
Because they didn't talk to you?
They didn't communicate and they entered my apartment without permission. They violated my rights. Not only one.
You call, say I have a leak. They at some point, because that's an emergency situation, enter your property. And that's your claim?
They entered my property the same night to fix the leak. And then they tried to enter my property 2 weeks prior to the leak happening to enter my property to fix it with no communication. They came to clean my couch a week after the problem had already happened and my couch was ruined. That's a $2,000 couch that was ruined. The leak was not only in just one part of my apartment, it spread throughout the whole entire apartment. There were cracks in the ceilings that were supposed to be repaired from construction that never showed up.
Entering your unit inconvenient.
It inconvenienced me because I was not only dealing with just
You know
the
what?
leak.
You got your witnesses here today.
I do. Your
I'm gonna squeeze you in because this is
I also have a
gonna be
witness.
a quick trial.
I also have a witness here.
That's fine. I'll hear from everybody, and then I'm more than happy gonna render that. The only issue is that I have criminal cases; those have to take precedence.
Absolutely.
But I'm ready to hear this today. It's not going to take time at all. I'm going to tell you right now because I do not.
This is one of the strongest moments in the entire case. The judge is being brutally honest. He doesn't understand her claims, and more importantly, he's not convinced by them. That's a major red flag for any defendant. When a judge with decades of experience says your argument doesn't make sense, it usually means you're in serious trouble. But notice, he still gives her a chance. He's willing to hear the case, call witnesses, and go through the full process. That's fairness in action. Still, you can feel the pressure building. At this point, what would you do? Keep fighting or try to settle?
I'm going to let you know, young lady. I will hear anybody's claim. I do not understand your claims, and the claims don't make much sense to me.
And I will make sure that I will make them make sense.
They don't make sense to me. Young lady, I'm trying to communicate something to you. I've been doing landlord-tenant for over 35 years. Your claims don't make sense. But if you want to go ahead and call witnesses, do all the questioning, go through all of that, we'll do it.
Okay.
And then I'll render my decision and you're stuck with it.
Thank you, Your Honor.
They can't get to I haven't called that one.
Excuse me, Your Honor. I offered the plaintiff, I'm not exactly sure, $2,000 within 2 days. Do you know?
Did you propose that to them?
Yes.
And what did they say?
They left. I'm not exactly sure what I'm supposed to do.
What do you mean?
Should I go out there and try to talk to them, or should I just wait here and come back and decide if they want to talk to you?
So you have an offer to make to them of paying $2,000 in a couple of days? Go see what they say. I'm never doing this again. Buck Road, Family Dividend versus Baker.
Good afternoon, Your Honor. Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Okay.
Janae Baker.
I have before me a consent order for conditional dismissal that indicates that the defendant would agree to pay $2,000 on or before 5 p.m. on October 30th, 2025. No personal check, only certified funds. Defendant pays on or before October 30th, 2025. Plaintiff will waive the remaining balance. That's basically the court's full understanding, except to make it clear that if you don't pay that, then plaintiff would be entitled to a judgment of the full amount of the including cost of $3,055.63. You understand that, ma'am?
Yes, ma'am. Yes, sir.
Are there any other questions that you may have regarding this conditional order dismissal?
No, sir.
All right, so you understand everything?
Yes, sir.
All right. Thank you folks for resolving it. I will sign off on that. And you have to advise you, since you are here unrepresented by counsel, you have 3 business days to think about this. If you think that there's some legal reason on your part or some right you didn't assert, you'd have to file a motion with the court within that time frame. You understand that?
Yes, sir.
Doesn't mean that I would grant you have that time to think about it, file that motion. You understand that?
Yes, sir.
All right, very good. Ms. Baker, let me say something to you. Sometimes you can come in with the greatest of all intentions, but I think you could have had this resolved a whole lot earlier had you maybe proposed that to counsel and kind of worked it through, realizing what your potential liabilities may have been in this case. Okay? So if nothing else, I hope not only with regard to a satisfactory settlement of this, that you learned something else from this.
Absolutely.
Okay.
Thank you, Your Honor.
Thank you, folks.
In the end, this case didn't go to a full trial, and that might have been the smartest move. The defendant agreed to pay $2,000 to settle a claim that could have cost her over $3,500. That's a significant reduction, but it came after a long and difficult process where her arguments struggled to hold up under legal scrutiny. The judge made it clear, good intentions don't replace proper legal steps. This case is a powerful reminder that in landlord-tenant disputes, documentation, communication, and timing are everything. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.